What I'm going to present this morning are very preliminary thought. It's not a full-fledged paper on whether EU consumer protection law, something that's very general, could apply to some marketing practices using big data. So big data is confusing. It's confusing for lawyers. We heard a lot about that yesterday. It's also confusing for consumers. I think, given the discussion we've had, I can set the stage pretty quickly now. I don't need to dwell on the fact that most citizens and consumers don't understand what data is collected or how it is used. This is true for data collected by government. We were all a bit scared off by David about the Connect project yesterday, but here I'm talking about data collected by traders. This creates an issue of trust. If people have the feeling that traders are doing weird things with their data, even if they don't know what exactly it is, they may be reluctant to engage in certain transactions. There is some empirical evidence of that in a 2015 report by the Competition and Market Authority from the UK. I won't go into this in the interest of time. Now, the EU point of view on this is that lack of trust is a problem. And it is a problem because it hinders trade, particularly from the EU point of view. What's problematic is that it hinders cross-border trade, which the EU is so adamant to promote. So the next question is, what do we do to create trust? The traditional tools that we find in EU law as it stands is information disclosure. Now, the exchange we've just had reminded us of the argument, and I won't dwell on this either. So disclosure is mandated. Traders have to tell consumers what data they collect, how they're processing it. Other legal instruments require to have consumers consent to cookies, consent to automated decision, like we discussed yesterday. Now, how good is this? Probably not very good, because people don't read. And when it comes to consent, you really want to ask, oh, really? And again, what you explained, Omri, illustrates this perfectly. You don't necessarily understand what you consent to, and even if you did, you really need to make that train booking. So of course you're going to consent to their privacy policy. Do you really have a choice there? So the next question that comes to mind is, can we do better? Do we have other tools that we could think of? And there are a variety of legal tools around, and the one I'd like to explore is a tool from consumer law. Now, the question here that I want to ask in a future paper, if I get to that, is, can horizontal consumer protection rules protect consumers against something that we could call unfair use of their data? Of course, the hard question is, how do you define unfair use? And that would precisely be the aim of the research. So why ask this question? I said it in general terms, but there is a specific legal reason why this question deserves to be asked. This is because at first thing you could say, wait a minute, isn't that the very function of data protection rules, to protect consumers against unfair use of data, whatever unfair means? It's true, of course, but the general data protection regulation that we have applies only to personal data. And personal data is defined as any information relating to an identified or identifiable natural person. But large amounts of non-personal data can be put to valuable commercial use in marketing practices. In other words, big data, the data that is collected and processed for marketing, for targeting, is not necessarily personal data within the meaning of this regulation. So that leaves out a large scope for applying a more general provision where the specific provision doesn't apply. And maybe some of these uses of non-personal data could be unfair. And if that is the case, then consumer law may help fill that gap. So because this learned audience may not be entirely familiar with EU consumer protection law, I'll start by just taking you through the basic provision that I am discussing, and then give a few examples that I'm really offering to discussion here. So take my word for it, I looked at all consumer law. There's no trace of a specific provision about unfair use of consumer data. That's why I turn to a very general provision, perhaps the most general provision of all in EU consumer protection. It says that unfair commercial practices shall be prohibited. This being a directive, it means that member states have to prohibit in their own national laws. Then it goes on to define what an unfair commercial practice is, and it's a two-pronged test. A commercial practice shall be unfair if A, it is contrary to the requirement of professional diligence, and B, it materially distorts or is likely to materially distort the economic behavior with regard to the product of the average consumer, whom it reaches or to whom it is addressed, or of the average member of a group when a commercial practice is directed at a particular group of consumers, say teenagers. Now, materially distort is one of the confusing elements in this definition. The directive further defines this concept by saying that a decision is materially distorted if the consumer's ability to make an informed decision is impaired and causes him or her to take a transactional decision that he would not have taken otherwise. Pretty much that's complicated language to say what psychologists would call influence. Now we're all influenced all the time by a variety of things in our decisions. So you might wonder whether there's a threshold. The answer is not really, and if there is one, it's really low. Just see this. This comes from the guidance notice. There's an extensive guidance notice on this directive, and there the Commission gives example of things that could be unfair, and it includes not just pushing someone to buy or not buy something, but also causing someone to spend more time on the internet engaged in a booking process. Now, that happens fairly often, probably. So we have essentially three elements here. Whether the practice is contrary to professional diligence, that, the question here, is it evil? And that probably refers us to marketing ethics. Is it something acceptable? Does it distort behavior? So from a marketer's perspective, the question here would be, is it effective? And is it effective in influencing behavior? And third element, the average consumer, which is an abstract normative standard. It doesn't refer to any statistical average. And we have in European law a very weak evidential requirement here, but empirical data is still relevant. So now, against this background, I'd like to give two examples of practices of which I don't know if they are unfair use of private data, but I use them as heuristic to try and think about this. The first example is personalized prices, and the second is emotion tracking in advertising. So, personalized prices first. We know about personalized offers. We've all bought a lot more from Amazon than if Amazon hadn't, known us so well and suggested books and other goods that we might like. Personal suggestions certainly influence our purchasing decisions, but no one would really be tempted to say that this practice is against professional diligence. It seems okay for an online seller to suggest things you might like. Now, how about personalized prices? Big data can be used to estimate readiness to pay, sometimes very accurately. And you might think, well, isn't that a good thing? After all, perfect price discrimination is highly efficient in economic terms. Yes, but is there a fairness objection to that, is what I wonder. Is it fair, for example, that I'm charged more for a flight that I'm booking from an Apple computer than someone booking the same flight from a PC? I personally don't think so. Is it fair that price goes up every time I look up a flight option if I run this search multiple times? I also don't really think so. What I think obviously doesn't matter. But I was toying with the idea of doing something a little bit along the lines of what you've been explaining, Omri, is go to people and see try to survey perceptions of unfairness. I haven't run any studies yet, but I have looked at studies that were around and found an interesting one, which is already 10 years old. And of course, one study is not enough, but here are a few elements. First point, consumers will consider a price unfair if it differs from the price paid by other consumer. So if I feel discriminated because I'm an Apple user, apparently I'm not the only one who perceives this as unfair. And if they're not involved in the price setting process. So that distinguishes the situation where the trader is saying what the price is, or price setting mechanisms such as auctions, where what the buyer does influences the price. Second point, unfairness is perceived as greater if price vary in a short period of time. So if I look up one flight and 2 hours later the price has gone up, I'm likely to feel it's more unfair than if it's more expensive, but it's 1 week later. Third, consumers have a higher fairness perceptions and satisfaction regardless of the price level when they play a role in price setting process rather than when prices are set by the retailer. So participation seems to matter in the fairness judgment. So these are this comes very very short of a full analytical framework but it's there are a few elements for beginning to think of how of an analytical framework for unfair, not so much unfair prices as unfair pricing mechanisms, an unfair way of setting a price. The second example I wanted to share with you is emotion tracking in advertising. So here you have a bus stop in London with an ad, and this bus stop is equipped with a camera that scans your face, and because it has learned from scanning many other faces what faces look like when people are happy and unhappy, it will infer your current emotional state from that. Now, you might think, there is nothing more intimate as emotional state, and surely there's got to be personal data, but guess what? It's not, because you can do this without storing or processing data that identifies the person or makes the person identifiable. And the device is set to adapt the ad to the emotional state as tracked by this setup. And the ad will change itself to make itself more appealing to you if you look unhappy when you look at the ad. So what does that, so this is just a definition by a colleague, a social scientist who's working on that a lot. Could our super general provision on unfair practices apply to this? Let's look at it step by step. Emotions influence behavior. That's a fact of life. And it's not, obviously not problematic. Advertising elicits emotions, also not problematic. We've known this forever. Tracking emotions, which is what this does, is not per se problematic. Because the measure, just collecting data, does not in itself influence behaviors. But tracking emotions to leverage that knowledge about emotional state and influence behavior more effectively, could that be contrary to professional diligence? And if that really makes this ad more effective, could you say that then it materially distorts behavior? So I think that this is anecdotal, but it raises a more fundamental question, is because something is made more effective by using big data, does that change the way the law should analyze it? And I think this is a question that we find in both examples, both in the price discrimination example and in this example. These practices are new in the way they're done now, but in and of themselves, they're not super new. Price discrimination, you used to, oops, sorry, I meant to show. This is price discrimination. You go buy fruit and vegetables on a market, maybe Omri will get a better deal because he looks like a better negotiator than I would. That's price discrimination. And we don't think it's unfair. And the same with making ads more potent. Could that become unfair just because it's more efficient? I don't know. So just to wrap up, the prohibition of unfair commercial practices could apply, that I'm sure, to database marketing practices. So it needs to be on the radar of both marketers and lawyers that advise companies doing online marketing. And this is especially of a special significance where the data protection rules do not apply. Now, we still lack a good analytical framework to think about unfairness, and more work needs to be done, including empirical work on, I think, perception of unfairness, just like the things you did on perception of meaning of contract. And the aim would be to elicit dimensions of unfairness judgment in the commercial context. We have a hunch of a few dimensions, such as interpersonal comparison, why am I discriminated against, and procedural fairness about price mechanism. Is the mechanism fair? So, to be continued, and thank you for your attention.